Well, friends, welcome to today's session. This is, I think, this is the fifth session on salary chapter. Already, we have covered the basics of salary, like some of the important elements are already been covered. Then allowances, I think that part is over. And today we are supposed to start with the perquisite part. So very quickly, we'll see. We'll do a kind of quick recapitulation of allowances. Then we'll move to perquisites. Going to share the screen with you right now. Do you have any query as regards to allowances? Anyway, recorded videos are available on YouTube. You can find out and you can do a quick recapitulation. So we have already learned that we can classify allowances for tax purposes into three categories, like allowances which are fully taxable, allowances which are partly taxable, and allowances which are fully exempt. Okay, these are the list of allowances which are fully taxable: dearness allowance, entertainment allowance, overtime allowance, like this. Most of the allowances we have covered. Entertainment allowance I have not taught you. I'll be telling you after some time. Similarly, partly taxable allowances, house rent allowances has been covered. Special allowances has already been covered. Fully exempt allowances, I had given you a brief idea about what are the allowances which are fully exempt. So these are the various categories of allowances we have discussed, and we have done some exercise also. We have used tax calculators or exemption calculator which are provided in the income tax department's website, and these exercises we have done various kinds of allowances. These are few exercises we have done in the previous video. If you watch our channel, you can find it out. And these are in fact special allowances. So different amounts are exempted depending upon the location and various other conditions. This part also we had discussed earlier. And here are few allowances which are fully exempted, like allowances to Supreme Court or High Court judges, allowances received from United Nations organizations, then compensatory allowances under Article 2 of Constitution, compensatory allowances given to received by judges, sumptuary allowances, these are also received by High Court judges. Okay, so this is in fact High Court judges and Supreme Court judges, they receive these allowances. This is for allowances for entertaining others. You can say this is a kind of entertainment allowance, one can say, that is exempt. Then allowances received by government employees who are working outside India. Not only allowances for periods are also exempt. We have discussed that thing. Allowances received by UPSC chairperson are fully exempt. So these are the exempted allowances. So up to this, these parts we have discussed, right? So now today we'll start this part, perquisites. Perquisites also some basic things I had already told you earlier. Perquisite means, can anyone explain me what is the meaning of perquisites? Can anyone explain me?
Remuneration.
Yes.
Meaning of perquisites or
Any
perks?
remuneration given to the employees in kind.
Yeah, remuneration given to employees in kind means these are primarily non-monetary remunerations.
Yes.
So this includes rent-free accommodation or concession in the matter of rent, or certain benefit or amenity granted or provided free of cost or at a concessional rate to specified employees. Will be lolling who are the specified employees, and if certain benefits or amenities are provided to them either free of cost or at a concessional rate, then that will be treated as a perquisite. It also includes amount paid by an employer in respect of any obligation which otherwise would have been payable by the employee. If some obligation is payable by the employee, but for some reason employer is paying that. In that case, that will be treated as a perquisite. For example, professional tax, which is a liability of employee, if that is paid by employer, that will amount to a perquisite. Okay, then many other items are there. Some payable by an employer, whether directly or through a fund other than recognized provident fund, approved superannuation fund, or deposit linked insurance fund. If any payments has been made other than these funds, then that will also amount to perquisite. Specified securities or sweat equity shares allotted to employee by an employer. If those kind of equity shares are allotted to employee by an employer, that will be also treated as a perquisite. Contribution to approved superannuation fund or recognized provident fund or national pension fund by employer in excess of 7,50,000 rupees. So this is an amendment this time. So you have to remember this amount. If contribution made to these funds in excess of 7,50,000 rupees, that will be treated as a perquisite. Similarly, annual accretion to the balance at the credit of recognized provident fund, national pension fund, or approved superannuation fund, which relates to the employer's contribution and included in the total income. And if that amount is exceeding 7,50,000 rupees, that will be also treated as a perquisite. That means employer's contribution in excess of 7,50,000 is a perquisite, as well as annual accretion to the balance, annual accretion to the credit balance of these funds. To the extent it exceeds 7,50,000 rupees, that will also be treated as a perquisite. Value of any fringe benefit, that means any additional benefit, shall also be treated as perquisites. Okay, so these are some perquisites we have seen, and we had also discussed this part. Perquisites may be received from the present employer or from past employer. It may be a contractual obligation, or maybe voluntarily employer might be giving. It is taxable under the head salary. Okay, if it is allowed by an employer to employee or his family members, if it is allowed to be used or to be availed by the employee or his family member, then it's a perquisite. It should result some personal advantages. It must be derived by the virtue of authority of employer. Because of that employment, that benefit or amenity must have been availed. Okay, so as you know, the perquisite should be allowed to the employee or his family member. Let us say free house is given. The house must be allowed for stay of employee as well as his family members. Family members includes here spouse, children, and their spouses, parents, servants, and dependents. This is the meaning of family members. Okay. Now, friends, having understood that, we'll see the list of the perquisites which are exempted. First, you see refreshment. If refreshment facilities are provided in the office, okay, tea or non-alcoholic beverages and snacks, etc., is provided during the working hours, or it may be provided during extended working hours, then these refreshment facilities are exempted. And free meals, if free meals are provided, they are also exempted, but only to the extent of ₹50 per meal is exempt. The excess is a perquisite. I think previous class we had discussed this point also. Suppose employer is providing you lunch for ₹80, then up to 50 it is exempt, then extra 30 rupees will be taxed. Okay, so condition is that cost should be within 50. It may be provided in the office or through non-transferable coupon. Non-transferable coupon is the kind of coupon which can be used only by the employee. An employee may take it and encash it outside and avail a free meal by using that. Okay, so that is called as non-transferable coupons. Free ration provided to armed force personnel are fully exempt. Goods manufactured by employer sold to employee at concessional rate, that is also fully exempt. Conveyance facility provided to employees for journey between office and residence and vice versa. If some facility is provided, conveyance facility, let us say office vehicle is coming and picking up the employees and dropping the employees. So those kind of conveyance facility, if it is provided, that is fully exempt. training cost and expenditure incidental to the training of employees, that is also exempted for PJ. Okay, and you already know the government employee, if they are getting some PJ for working outside India, that's exempt. Employers' contribution to staff group insurance scheme is exempt. Employers' contribution to pension or deferred annuity scheme is an exempted for PJ. Medical facility at the office is exempted for PJ. Medical insurance premium paid by employer is exempted for PJ. Periodicals and journals supplied by employer to employee is exempted for PJ. Okay. Telephone and mobile facility is an exempted for PJ. Free education facility to employees' children up to rupees 1,000 rupees per month per child for any number of children. If this free education facility is provided, that is an exempted for PJ. Health club facility or sports club facilities are exempted. Use of computer or laptop in the office are exempted from PJs. Okay. Few more items are there in the list. Quickly we'll see that. Rent-free accommodation given to High Court judges, Supreme Court judges are exempted. Rent-free furnished accommodation provided to officials of parliament, union ministers, leaders of opposition, etc. are exempted. Rent-free accommodation in remote area for employees working at a mining site, onshore exploration site, project execution site, dam site, power generation site are exempt. Porculates provided to chairman, retired chairman of UPC, etc. are exempt. And lastly, tax on non-monetary payments to employees. If employer is making some non-monetary payment to employee, and on that the tax part is borne by the employer, then the tax amount is an exempted payment. So there will not be further tax on this tax. Okay, so up to this I had briefed you in your previous class, and today just we quickly recapitulated. Okay, so this point number 22 means, let us say, some non-monetary benefits provided by the employer to employee, and employer is bearing tax on that. Okay, that tax portion should not be again included as a perquisite in the employee salary, and further tax need not be paid on that. So this is why it is said tax on non-monetary payments to employees are exempted. Okay, up to this I think it is clear. Now we'll start afresh a new concept. Okay, did you get idea what are the things included in perquisite?
Yes, sir.
Okay. Yes. Okay. Now friends, here we'll do one thing, we'll remember. Now you have seen some of the perquisites are exempt, some of the perquisites are exempt subject to certain conditions. Some of the perquisites are totally taxable. So here we need to understand. Now what we'll do, now we'll classify your employees into something called as the special category employees, specified employees. There are certain specific perquisites which are taxable only for specified employees. So therefore now there is a need to understand the meaning of specified employees. Okay, so first we'll learn that, then we'll be understanding further what are the other things relating to perquisites. Now, friends, we'll be learning like this. Specified employees is explained in section 17(2)(3). Okay. Now you see section 17, subsection 2 clause 3 you see. So three kinds of employees shall be regarded as first specified employee. First category is the director employees. If employee is a director. Second is employee who has substantial interest. He is holding substantial interest in the organization, in the entity. Then he is also a specified employee. Then employee with gross taxable salary more than rupees 50,000 during previous year. Okay, gross taxable salary, and here salary means I am talking about annual salary. His annual salary if it's more than 50,000 rupees during previous year. He's also a specified employee. Okay, so let us one by one we'll see. First is director employee. Director means he's an employee plus he's a director in the company. Then even if he's a director for a single day, still he's a specified employee. Okay, only for company where is a director. For that company only he will be treated as a specified employee, not for other companies. And here we mean the company director, not cooperative society director, or not any other entity's director. You may call someone as director, but here when I say director employee means I'm referring to company directors only. Okay, so if some employee is a director, then he is a specified employee. Next is employee has substantial interest. Substantial interest means he must be holding 20% of voting power. Okay, this may be held individually. Okay, it should be held individually, in fact, not with relatives. That is individually. If that employee is holding 20% of at least 20% of the voting power, let us say he is having 20% of share capital he is holding, then he is an employee with substantial interest. Did you understand this? Employee with substantial interest.
Yes, sir.
Okay. Third category of employee is that employee with gross taxable salary more than rupees 50,000 rupees per more than rupees 50,000 during previous year. Here, taxable monetary payments excluding non-monetary purposes, employers' contribution to provident fund, that has to be taken into consideration. And after allowing deductions under section 16, we have to find out what is his taxable salary. Okay. So after this deductions and after excluding perquisites and employees' contribution, we have to find out how much monetary payment he is receiving. And if it is more than 50,000 rupees per annum, then he is a specified employee. These three categories of employees shall be regarded as specified employee. I repeat, director employee, employee with substantial interest, and employee with gross taxable salary more than 50,000 rupees during the previous year. Okay, can you remember these three?
Yes, sir.
Okay, what I told you right now, this has been explained in this slide. A director, even if he is for a single director for a single day, he will be still regarded as a specified employee. Okay, and here we are talking about company director. He may be a nominee director, he may be a part-time director, but still he shall be regarded as a director. And when I say employee holding substantial interest, and substantial interest means 20% or more voting power in the company. Okay, and here you have to see the 20% voting power must be held in his own name, not along with relatives. For example, let us say if Mr. X holds 18% equity shares of a company and his wife holds 8%, then 18 plus 8 taken together is 26%. Okay, but still, Mr. X will not be treated as a employee with substantial interest because individually he is holding less than 20%. Are you getting it? And in that
Yes,
case, that employee shall be treated as specified employee only for that company, not for other company. Third category of specified employee, that employee whose gross taxable salary is more than 50,000 during previous year. Here we have to take all taxable monetary payments, excluding non-monetary purchases, excluding employees' contribution to provident fund, and this is after allowing deduction under section 16. Will arrive the amount. If it is exceeding 50,000 rupees, it shall be treated as a specified. Okay. Did you understand the concept of specified employees? Yes or no?
yes, sir. Yes, sir.
Okay, friends. Now, having understood this, having understood what is perquisite, and having seen some of the perquisites are exempted, and having understood that who are specified employees, now we see the first perquisite, that is rent-free, unfurnished accommodation. Okay, rent-free, unfurnished accommodation. How tax treatment will be done? Let us discuss this thing. Rent-free on accommodation, unfurnished accommodation, we have to understand this concept. First of all, if it is provided to judges officials of parliament, union minister, leader of opposition, or employee working at some specified places. We'll be learning what are these places. Then what is the treatment? That is fully exempt. Okay. Unfurnished rent-free accommodation is fully exempt. It is provided in this situation. Okay. Now, second, one more category of employees, the government employees. If it is provided to government employees, then government fixes a fee called as license fee. That license fee shall be treated as the value of that per. Okay, license fee is the value of that per. That figure we need to find out what is the license fee that will be treated for government. For other employees, there might be two situations. Employer might have given his own house, or employer might have hired a house. Employer might have taken a house on rent and might have given to the employer. If the house is employer's own house, then treatment will be different. Treatment is that a specified percentage of the salary, depending upon the population of the place of accommodation. You have to see which place accommodation has been provided. On that basis, specified percentages will be treated as the value of the per place. I'll be showing you that percentage shortly. And if the house is hired by employer, the rent paid or payable by employer or 15% of the salary, whichever is lower, that amount shall be treated as the value of rent-free or furnished accommodation. Did you understand this concept?
Yes, sir.
Okay. So I repeat, for these persons, judges, officials of parliament, union ministers, etc., it is fully exempt. For government employee, license fee is taxable. For other employees, if the house is owned by employer, specified percentage depending upon the place of accommodation and population. And if the house is hired, taken on rent, then rent paid or payable, or 15% of salary, whichever is lower, that has to be taken. Okay. And same thing, let us see in this particular slide. You see, when it is fully exempt, and for government employees, license fee shall be the value of the per day. License fee shall be determined by the central government in accordance with the rules framed by the government. This is how license fees are determined. Okay. Now, if house is provided in these places, we have discussed this earlier, like mining site, onshore exploration site, project execution site, dam site, power generation site, and temporary offshore site. Okay. Then some specified located places, remote area, 40 kilometer away from the town, having population not more than 20,000 rupees. Right? So located 800 kilometer or more from municipality. Okay. Or cantonment board, etc. In this situation, if house is provided, it is fully exempt. For other employees, for government employees, for other employees, so as it depends upon place of employment. It depends upon where accommodation is provided and population. So if the population not exceeding 10 lakh, then 7.5% of the salary. If it is exceeding 10 lakh but not exceeding 25 lakh, then 10% of salary. If it is exceeding 25 lakh, then 15% of salary. Okay, you have to see what is the population. Okay, if the house is owned by employer, so this will be the value per plate. If his house is hired by the employer, as we have already discussed, rent paid or payable, or 15% of the salary, whichever is lower. So if the house is owned by employer, then this percentage shall be treated as value per village. If the house is hired, then you have to arrive according to this formula: rent paid or payable, or 15% of the salary, whichever is lower. Did you understand this?
Yes, sir.
Okay, this is how perquisites, that is rent-free or unfurnished accommodation, shall be valued. Okay. Now, As you have already seen, here you see 7.5% of salary, 10% of the salary, 15% of the salary. Here also you have to calculate 15% of the salary. Then what is the meaning of salary for rent-free accommodation? For rent-free accommodation, the meaning of salary is slightly different. So let us see, this is the meaning of salary. Salary for the purpose of rent-free accommodation. It includes basic, it includes DA if it forms a part of retirement benefit. All commissions are to be included, whether it is fixed as a percentage of turnover or not, that doesn't matter. All commissions are included for rent-free accommodation in salary. Then contractual bonuses are included. All other taxable allowances, only taxable parts shall be included. Any other monetary payments, whatever name, whatever maybe the name, okay, but excluding employer's contribution to property. So all these monetary payments shall be included in salary for the purpose of rent-free accommodation. So this is the meaning of salary for the purpose of rent-free accommodation, and you already know how to arrive at the value of rent-free accommodation. Okay. So the salary for the purpose of rent-free accommodation includes these items. It does not include these items. It includes basic, DA, bonus, commission, fees, and other taxable allowances. It doesn't include DA if it's not for retirement benefit. Employer's contribution to PF, exempted allowances, perquisite value, and lump sum payments at retirement. It doesn't include these items. It includes these items. Okay. Right? Few other points you have to remember here. Fair rent and municipal value, etc., is not relevant for the purpose of valuation of perquisites of rent-free accommodation. Movable house is also an accommodation, and it is taxable. Value of the perquisites needs to be arrived. And when computing the salary, we have to take the salary only for the period for which house is provided, house is occupied as a perquisite. Okay, so accommodation provided by central or state government to deputed employees, if that is the kind of situation where accommodation is provided by central government or to a non-government employee who is servicing on deputation. Let us say there is a non-government employee who has gone to a government department and working on deputation. That non-government employee shall be treated as a non-government employee, and accordingly, value of the perquisite shall be arrived at. Okay, and here, if someone has received salary from multiple sources, then all these salaries shall be aggregated. Okay, if the employee is working with more than one employer, the salary for all these sources shall be aggregated for the purpose of valuation of perquisite. This concept we have to also remember. Okay, uncommuted pensions from another employers shall form a part of salary also. If it is uncommuted, it is received on a regular basis, that forms a part of salary. Gratuity received during continuation of the service shall be considered for computing salary for rent-free accommodation purposes, as all monetary payments are included. But however, lump sum gratuity received at the time of retirement is to be ignored. Okay, gratuity during continuation of the service is included for rent-free accommodations value, but lump sum gratuity received at the time of retirement shall be ignored. Leave encashment received during continuation of service shall be considered while computing the value of rent-free accommodation. But however, lump sum leave encashment received at the time of retirement is to be ignored. Advance salary, arrear of salary received will not be considered for computing rent-free accommodation. Okay, so if suppose somebody has received salary in advance or arrears of the salary is been received for rent-free valuation of rent-free accommodation for that particular period, only that relevant period's salary shall be taken. Advance salary, arrears of salary shall not be considered. Okay, and rent-free accommodation is taxable in the hands of all employees. That means whether they are specified employees or non-specified employees, that doesn't matter. It is taxable for all employees. You already know who are specified employees. Okay, director employees, then employee having substantial interest and employees whose gross salary is more than 50,000 rupees during previous year. They are specified employees. But rent-free accommodation is a taxable purchase for all. Okay, is it clear to you? Yes or no?
So what's the reason for not including, including uncommuted pension?
What is the reason for not including
For
commuted pension?
including uncommuted pension too.
Uncommuted pension is just like salary now. Uncommuted pension means pension which you are receiving on regular basis, just like salary. So it is just like salary. But commuted pension is which you received in lump sum. Therefore, uncommuted pension from another employer shall form a part of salary because all the salary needs to be commuted.
Okay.
Okay, so pension is also your salary. So when you are arriving at the salary, so that pension should be treated just like salary. Okay,
Okay.
yeah, friends. In case more than one rent-free accommodation is provided, then all such houses are taxable. But however, in case of transport, let's say employees transport from one place to another, and there are two houses in both the places. There's one house each, so total two houses. The value of both the houses should be included normally, but value of the perquisite shall be for the accommodation which is a lower value only for 90 days. Thereafter, both the houses are taxed. So when employee is getting transport and two houses are provided, one house is at place A, another house is at place B, you have to see the whose value is lower. That shall be treated as the value of the perquisite for 90 days. Okay, for the transition period. After that, both the houses shall be taxable. Okay, is it clear to you?
So thereafter value shall be for both the houses means?
Sorry, could
So
not hear you.
thereafter the value shall be for both the houses means both the houses should be
Yeah,
valued.
if two houses are provided, then
Yeah.
both the houses shall be treated as perquisite.
Okay.
If employee surrenders one house, then
Yeah.
okay, only one house is added.
Okay.
Okay,
Okay. Sir.
right. So this was the treatment for rent-free unfurnished accommodation. Now we'll see valuation of rent-free furnished accommodation. Then what we'll do? Process is very simple. First, you have to assume that Ajib house is provided as unfurnished accommodation. And if it is unfurnished accommodation, then we have to do valuation like this. Okay. For these people, it is exempt. For government employees, license fee. And for other employees, the house is owned by employer. Then specified percentage of the salary. If it is higher, then rent paid or payable or 15% of the salary, whichever is lower. This is how we have to do valuation. Okay. And the percentage of salary is mentioned here. If the house is owned by employer, 7.5%, 10%, or 15% of the salary. Okay. So what we'll do in case of furnished accommodation, first we'll assume as if house is provided like unfurnished and accordingly we'll find out its value. Then what we'll do for furniture, we'll make some addition. If furniture is owned by the employer, then add 10% of original cost of the furniture. Okay, very simple. If the furniture is owned, employer has purchased and given that furniture, just add 10% of the original cost. Every year the 10% has to be added. Okay, every year this has to be added. And if furniture is not owned, but it is hired by the employer, then actual hire charges shall be added as the value of the furniture. Are you getting? Did you understand this?
Yes, sir.
Okay, and few more points you need to remember in this connection. Furniture includes household appliances like TV, fridge, AC, etc. And the value of perquisite of furniture is same for both the government and non-government employees. Written down value of the furniture or market value of the furniture has got no relevance. Only you have to see if it is higher, actual higher charges. If it is owned, then 10% of original cost. So it will be taxable every year, even after 10 years. So 10 years, you see 10%, 10%, 10 years means 100% of the furniture has already been taxed, but still it will continue to be taxed. It's applicable both for specified and unspecified employees. It's applicable for all. Okay, for government and non-government, same treatment. And this you have to see the 10% of the original cost of the furniture or actual hire charges. As what is applicable, that will be the value of furniture. And once you know value of furniture and value of unfurnished accommodation, you can combine them, you can find out value of furnished accommodation. Is it clear?
Yes, sir.
Okay. So same thing is explained here. Valuation shall be made as if employee has been provided a rent-free accommodation. The amount so computed shall be written. If this is a different concept, in fact, if this kind of accommodation is provided at a concessional rate, let us say employer has not given the accommodation free of cost. He's charging something. Let's say accommodation is worth 50,000, but employer is charging 5,000. Then what will happen? First, will arrive at the value of rent-free accommodation. Then whatever rent is payable, that will be reduced. So value of the perquisites will be 50,000 minus 45,000. So 50,000 minus 5,000. So 45,000 will be the value of concession. And concession is a perquisite. Okay, did you understand this example?
Yes, sir.
Now, one more kind of rent-free accommodation which may be provided in a hotel, motel, or service apartment, or guest house, etc. So the value is taxable. Any any of this kind of accommodation taxable. Taxable for both government as well as non-government employee. But how to arrive at the value per plate? We have to use this formula. 24% of the salary for the period for which accommodation is provided for, or actual charges paid. You have to find out that accommodation is provided for 1 month. So 1 month salary into 24%. Then actual charges paid, whichever is lower, that amount is the value per plate. Okay. But however, so these facilities are exempted for a period not exceeding 15 days for the purpose of shifting. Let us say employee shifted from one place to another place, and the new place he has been provided accommodation in a hotel, motel, guest house, service apartment, etc. So for 15 days, this kind of perquisites shall be treated as exempt. But if the facility is extended beyond 15 days, then it will be taxable. Okay.
Okay, sir.
Now, so both furnished accommodation, unfurnished accommodation we have completed. Now, friends, we'll see this thing. Insurance premium paid by employer. If employer is paying insurance premium, it is fully taxable, both for specified as well as unspecified employee. But since the employee insurance premium is paid, employee may be eligible for deduction under Section 80C. That's a different thing. That deduction can be availed. In case medical insurance premium is paid by employer, this is not taxable, but it is not deductible under Section 80DD. 80DD means medical insurance premium paid. So that deduction will not be available. But it is not taxable for when employer is paying medical insurance premium, it's not a taxable. Life insurance premium paid, it is fully taxable and deduction is available. Medical insurance premium not taxable and deduction not available. Okay, so this is the difference between these two. Life insurance premium and medical insurance premium. Are you able to understand the difference?
Yes. Yes, sir.
Okay. Then you see some other facility we'll be talking about. This is few more percolates like gas, electricity, water facility. If these facilities are provided, they are also percolates. If these facilities are provided from one sources means employer's one source. That is, the employer is manufacturing gas or employer is producing electricity and he is extending this facility to the employer. Then the manufacturing cost of the employer shall be treated as the value of purchase. But if the employer is not manufacturing, employer has hired these facilities and extended it to employees. If these facilities are hired or purchased, then the purchase or higher prices paid by the employer shall be treated as the value of the purchase. That means on actual basis, whatever is the purchase price or the higher charges, that shall be treated as the value of the purchase. Okay, and here two more conditions you need to remember. If the facility is in the name of the employee, let's say gas is provided, but gas connection is in the name of the employee, it's taxable for all employees. But if the facility is in the name of the employer's gas, employer's electricity, but employee is using one, then it is taxable only for specified employees, not for all employees. So only when the facility is in the name of the employee, it is taxable for all. But if it is not in the name of the employee, it is the name of the employer. It is taxable only for specified employees, and you already know who are the specified employees, right? Okay.
Yes, sir.
What I told you right now, this is a summary of this thing, right? Provision of gas, electricity, water provided free of cost or at a concessional rate. So these are the steps you have to follow. If it is purchased or hired, then first find out the cost of employer, what is the amount paid by the employer. Then if it is a concessional thing, that means some money is recovered from the employee, then less amount recovered from the employee, then the taxable value is step 1 minus step 2. And if it is supplied by the employer from own sources, then manufacturing cost minus recovery, balance amount is the taxable value. So whenever things are made available or percolates are made available at a concessional rate, then first you have to arrive at the value of the percolate. Therefrom, we have to deduct the value of concession, and the difference is the taxable value. Okay, is it clear to you?
Yes, sir.
Okay. Next category of percolate is the provision of domestic servant. Here you have to see 4 situations in fact. First situation is that servant is appointed by whom? We'll see that. Second, we'll see servant salary is paid by whom. Then we'll see what is the value of the percolate and is taxable in whose hand. So we'll analyze the situation into 4 parts. Then we'll see. First situation is that if let us say servant is appointed by anyone, maybe employer, maybe employee, but servant is salary is paid by employee. If servant salary is paid by employee himself paying the servant salary, then it's not a percolate. So value of the percolate is nil, and consequently it is not taxable in anybody's hand. Okay, I think past row you have understood. Okay.
Yes, sir.
Second is appointed by employer servant. You can say company servant, entity servant. But and salary is also paid by employer. Employer servant, salary is paid by employer. But it's a perquisite because employee is using that servant. Then how to arrive at the value of perquisite? Actual cost incurred by the employer and the servant. So the value of the perquisite shall be whatever is the actual cost you have to see. That means if salary is paid by the employer, the salary amount we have to take. And it is taxable only in the hands of specified employees, not in the hands of all employees. So if servant facility is provided, it's taxable only in the hands of specified. Okay. Now, third situation is servant is appointed by employee. Employee's own servant, but salary is paid by employer. So this is definitely a benefit. Employee servant, but payment is paid by employer. Then actual cost incurred by the employer on that servant is also the value of work rate, but it is taxable for all employees. Previous situation you had already seen it is taxable only for specified employees. Okay, when employer servant and salary is also paid by employer, taxable for specified employees. But employee servant and salary is paid by employer, then it is taxable for all employees. Okay, this is what we are talking about. Provision of domestic servant. We are not talking about servant allowance. Servant allowance is fully taxable. We are also not talking about reimbursement of servant cost. Reimbursement means first cost is incurred by the employee and subsequently employer is reimbursing that. Reimbursements are fully taxable. Allowances are also fully taxable as regards to servant. And here servant includes cook, gatekeeper and maid. And if the servant facility is provided at a concessional rate, then what will happen? We'll find out what is the value of that per rate. Then we'll find out how much amount is recovered from the employee, and the balance amount is the value of concession which is provided to the employee, which shall be treated as a per. Did you understand this?
Yes, sir.
Okay. Now, next facility is about gardener's facility. It's fully taxable to the extent cost incurred by the employer. Gardener facility and garden maintenance cost is exempt if the following three conditions are met. So first of all, we have seen it is fully taxable. Okay. Normally it is fully taxable, but in which situation it is exempt? First, you have to see rent-free accommodation is provided. House is provided free of rent. Accommodation is owned by the employer, and the gardener is appointed by the employer. That means house is employers, gardener is employers. Okay, and only employee staying there. Rent-free accommodation is provided. If these all the three conditions are met, then only gardener facility is exempted. In fact, what is happening when the house is employer's house, then garden is also employer's garden. Only employer's gardener is maintaining employer's garden. So if you analyze from that point of view, we'll find out it should be exempted, and accordingly it is exempted. Okay, are you clear up to this?
So can you just repeat this one, gardener facility?
Gardener's facility. Okay, here again we are not talking about gardener allowance. We are not talking about reimbursement of gardener's salary. Those things are different. Now, gardener facility means this facility is provided. Gardener is provided if you can use it. It is fully taxable. If gardener facility is provided to an employee, it is fully taxable to the extent cost is incurred by the employer. Suppose in your house you are staying and employer has provided a gardener. Then whatever cost the employer is incurring, that shall be treated as a purchase for you. But if the house is not yours, it is the employer's house, and you are staying it in that house as a rent-free accommodation. Okay, and the gardener is also appointed by employer. So employer's house, employer's gardener. You are only staying there because it is given to you as rent-free accommodation. In that case, gardener's salary will be or gardener facility shall be treated as an exempted workday. Did you understand it now?
Yes. Yes.
Thank you. Now, is it clear up to this? Is it clear, friends? Yes or no?
Yes, sir.
Okay. So now, next perquisite is this is free education. Free education means it's not again education allowance. It's about education facilities provided to employee. So first you see, if education is provided to an employee, it's not taxable. If it is provided to the relative of employee, no, not relative. Relative means if it is provided to the children of employee, if you see, then different treatments will be there. Okay, it is provided to the children of employee children are applying this facility. And if it is provided to any other relative, that means except children we are talking about, it is fully taxable. Okay. First, let us eliminate two things. First of all, if it is education facilities provided to employee, not taxable. It is not taxable at all. Provided to anybody other than children, it is fully taxable. Now let us come to this point when education is provided, education facility is provided to children of the employee. Okay, first you have to see where it is provided. If it is provided in an institution which is owned or maintained by employer, then it is taxable, subject to an exemption of rupees 1,000 rupees per month per child. Okay, any number of children, there is no maximum limit. So if it is provided in an institution owned or maintained by the employer, taxable to the it is taxable, but exemption is up to 1,000 rupees per month per child. And if it is provided by virtue of employment in an institution not owned by employer, it is not owned by employer, it is not maintained by the employer, but by virtue of employment, this facility is provided. Okay, maybe due to terms of employment and because the situation is such that this education has to be provided, then it is again taxable, but subject to an exemption of 1,000 rupees per month. If it is provided otherwise, some other way it is provided, then the cost of education in the similar institution shall be taxable. Okay, it has to assume if the same facility is provided in some other institution, what will be the cost, similar kind of institution, that value shall be treated as a per rate, and that will be taxable. Okay, so here we have to remember, if institution is owned or maintained by employer, it's taxable, but exemption is there 1,000 rupees per month per child. If it is provided by virtue of employment, it's taxable, but exemption is there 1,000 rupees per month per child. But if it is provided through some other means, then cost of education in the similar institution shall be taxable. Did you understand? This is about education facility. Okay.
Sir, the exemption of rupees 1,000 is for how many childs maximum?
There is no max limit. Any number of children.
Okay.
Okay. So that subject to maximum for 2 children, that is not here. So you have to remember this. There is no max limit. Okay.
Yes.
So
Sir.
it can be availed for any number of children. Okay, but what I told you right now, it is about education facility. It's not education allowance. Education allowance is different. Reimbursement of educational expenditure is taxable. Reimbursement of school fee of family member of the employee directly to the school is taxable for all employees. In other cases, it's taxable for specified employees. Concessional facilities, if some amount is charged from the employee, then we'll first arrive at the value of the perquisite, then we'll reduce the amount collected from the employee, and the balance amount will be the value of the perquisites, value of taxable perquisites. And here, when arriving at the, let us say, per child 1,000 rupees, you have to remember, child includes stepchild, adopted child, but doesn't include grandchild or illegitimate child. Okay. And one connected point you have to remember, scholarship on the basis of performance is not taxable. Performance based scholarship is not taxable. Contribution to educational trust is also not taxable. Maybe employer is planning in such a way that employer is contributing to the educational trust, and from that trust benefits are received by the employee children, or employee children as the beneficiary of the trust, but contribution is made by the employer. In that case, those contribution to educational trust shall not be taxable. That shall not be treated as a purchase. This is about free education. So up to this, is it clear? Yes or no?
Yes, sir.
Sir, so in case of the education facility provided, the third option is not clear to me totally. Provided otherwise, this thing.
Okay.
If if it is not in an institution owned or maintained, then it can be in an institution which is not owned by the employer. Then how come the third option is coming? Can you
Okay.
just give
Third,
an example?
okay. Third, you see, the wordings of the law is that if it is provided otherwise, it can be anything. So if institution is owned or maintained by the employer, you know how treatment will be done. It is taxable, but exemption is there. If it is not owned, not maintained, but by virtue of employment that has been provided, then that will be there. But let us say some other ways employer is providing some facility. Okay, maybe employer itself is teaching, not through school. Some other means employer himself or employer itself is providing education facility, not through an institution. Or employer has made some arrangement, okay, where children can learn freely. If that kind of situation is there, then we have to see what is the cost of education in similar institutions, and that cost will be taxable. Let us say employer is providing in its own training center somewhere, is educating the children. Then we have to find out what is the cost of education in similar institutions. Otherwise, it is difficult to find out an example here.
Okay, sir.
Okay. Or so I thought, and to give an example like this by way of reimbursement. Let us say somewhere, but if it is a reimbursement, then that is the institute. Similar institution comparison will not arise in that situation.
So in that case, I think it will come in the second option if it is for reimbursement of fees in any institution.
The second option is that something like institution is involved. But in third option, whether institution is involved or not, we are not sure. It is provided otherwise.
Okay.
First case, you see there is an institution which is maintained. Second case also there is an institution which is not one. Third case it is otherwise. Otherwise means anything. If in case there is any possibilities. Okay, third option, maybe lawmakers at that point of time didn't think of any situation. So they have given just an additional option. If some other possibilities are there, then we have to find out the cost of education in similar institutions.
Okay, sir.
Okay. So this is about treatment of perquisites of education facility. Right. So next item is about value of interest-free loan, but I propose we'll do it in our next class. We'll stop here. Okay, is it okay for you? Few more percolates are still left. We'll be covering it in our next class. Okay,
Okay,
friends. After this, do you have any doubt? We'll again recapitulate major issues here.
sir, I had a doubt regarding the sumptuary allowance. One thing was there.
Sumptuary allowance. Okay, this is the allowance given by uh, or given to judges for entertaining visitors.
Entertaining visitors at their workplace or at their residence.
Maybe anywhere. Maybe anywhere.
Okay, thank you, sir.
For entertaining visitors, if that allowance is given to them. Okay, so thank you, friends. We'll catch up in your next class. Thanks a lot.